decision on the appeal request. And so that is what is pending at this point, but not an action before the planning board. So I would like to have some conversation among planning board members, and for the Moorashes, if there is anything factually, if you feel that there is an error in fact in anything that we put together, I would give you a few minutes at the end to comment on that if you'd like. But again, I want to stress that this is not procedurally an opportunity to re-argue the case or introduce additional evidence. So I would, Jack, do you have anything you want to add to that?
No, I'm fine.
Okay. So I'd like to open it up to planning board members. It's a little difficult for me to remember, everything that we had discussed at the time, and Jack and I have been pretty close to this issue recently, and so it's pretty fresh in our minds. But if there are questions that planning board members have, or if there are aspects of this that would be helpful for us to discuss further, we can certainly do that. However you would like to approach this, I think, is fine. But I do, I would like to come out of this with everyone, having a clear understanding of the revisions that were proposed to the notice of decision, and to be in agreement with those, and to reach a point where we can provide something to the appeals board.
So Paula, did you indicate that the draft revisions to the planning board order have been run through our town attorney, Kristen Collins?
Yes. Jack and I shared drafts of these materials with her. She had some comments which we incorporated. We went back and forth a few times actually on the drafts, and Jack and I met with her to talk about any final issues or changes that any of us might have, and that happened last week.
I wanted to maybe talk about a couple issues that might help. I think that to me, this case is actually very simple, although we've spent a lot of time on it. And when you look at the state rules, which we're bound by, it makes it crystal clear. And it says if the footprint of the original structure can be relocated or reconstructed beyond the required setback area, no portion of the relocated or reconstructed structure shall be replaced or constructed at less than the setback requirement for a new structure. So the original footprint, the total footprint of the original structure is 2,100 square feet. And we determined as the planning board that 2,100 square foot structure could be relocated or reconstructed at less than the setback requirements for a new structure. At the setback requirements for a new structure. There was no factor that limited placement of the 2,100 square foot structure beyond the 100-foot line. It would meet all setback requirements. It would meet all the greatest practical extent factors. And that is the end of the story for us. Once we make that determination, that's it. And the Colin Clark from the DEP, who was sent a copy of the decision, which is required under our ordinance and under state law to send a copy to the DEP, commented that the planning board got it exactly right in how it did this. I think the disconnect comes from the Moorashes looking at a 4,600 square foot house, and we're looking at a 2,100 square foot house. And that's very different. And under the state law, what we did was correct. And that sort of ends the inquiry for me. So I'd be happy to answer any questions.
I just wanted to say, well, thank you to Paula and Jack for doing all of this work, but that I did feel like that the simplicity of the analysis, Jack, did come through in this draft in a way that we weren't able to accomplish initially. And I thought it was much more clear. And I support the new draft.
You know, I think in looking at this and thinking about it some more, I think one of the things that contributed to the confusion around this is that the application came in as an application for a 4,600 square foot house. And I don't think that, you know, the way in which the planning board conducts business, I mean, it's very unlikely that we would say, you know, go away and come back to us with a 2,100 square foot house, and we're only going to look at that now. The proposal was for a house and an expanded footprint, and that's how the application was submitted. And I don't know that that's necessarily inappropriate, but at a variety of points through this proceeding, we had requested that the Morashes revise their plan to look at it again, to reduce the size of it or to reconfigure it so that it did meet the setback requirements. And that didn't happen. And I think that, you know, from my own perspective, I guess I was optimistic that we would see a revised plan that did conform to the setbacks and other requirements. And then that never really happened. And the analysis that Jack put forward is, you know, is absolutely correct from an interpretive perspective and in applying the shoreline zoning guidelines. Thanks, Jan. Others, other comments? John, Bill?
Sure, yeah, I'll jump in. Yeah, I agree that I think the revised language that you put forward does express what we've just been talking about here, and in a way that we hadn't satisfactorily captured. And I think the Board of Appeals remand is the result of that. And I think we've done exactly what they've asked us to do here. So I will support the revision language.
I would concur, Paula. I don't have any. I appreciate the additional clarity that we've been able to achieve, and I think that's been very helpful. I think it's a complicated. It seemed to be a complicated situation, but I sort of agree that it's actually not as complicated. And I think we were all struggling, including on both sides here, to sort of understand how to interpret things. And I think we've all learned a lot, and I think we can all be pleased that we learned a lot. And I'm sure the applicant won't agree necessarily with that approach, but I do think that you know, I would encourage the applicant to keep discussing this even after this process is complete. It doesn't mean that they can't do anything. It just means we have to conform to the rules that are before us. That's what I would say. Thanks. So I support the application.
Thank you, Henry. You know, and I would also add that the other thing that had been suggested throughout the proceeding was that it might be advantageous for the applicant to look at the language of the new ordinance, because we did revise that section, and there are opportunities in the language of the new ordinance that didn't exist previously that potentially could lead to a situation where a larger dwelling could be constructed and conform with the requirements of that ordinance. So there is that opportunity also. Henry?
I don't know how to raise my hand electronically, so I'm just going to raise it on the screen. So I apologize. I would just also add that you know, I wanted to add a little bit of constructive thought here related to the applicant. You know, I don't think that, I think here we're in what I would call sort of a procedural nightmare. If I was an applicant, this is where I would be viewing this as sort of a very difficult scenario. So I would just encourage this procedure to play out and be resolved. And then I would say maybe consider resubmitting a new application to the board with potential, as you're suggesting, Paula, with some you know, consideration for the revised ordinance that's available, in addition to now the understanding of the shoreland requirements from the state and the town. I would say that the efforts that they've gone to date are not for naught, and I think that they have an ability to be successful with their endeavor here in Reedfield. None of us here are sort of trying to prevent them from coming into Reedfield more permanently and having a nice home to live in. That is not our goal or our intent. And I think that I just wanted to say that out loud on the record, because I think, you know, I certainly feel uncomfortable as a member of this community being in this situation, but I also feel bound by my obligations to the rules to make sure we follow the rules. And that's really the quasi judicial mentality we have as planning board members. And I would hope the applicant comes back to the table in a constructive way, and we can have a much more collaborative discussion. Thanks.
Thank you for that, Henry. Anyone else? Bill, did you have any comment or question you would like to make?
I think that Henry has clarified the picture as much as it can be clarified until the applicant changes his frame of mind.
Anything at all further from planning board members? Did I get to everybody? And if not, Mr. Morash, I would offer you just a couple of minutes if you wanted to provide any comment, or if there is you know, something in particular that you are concerned is not factual or accurate in the redraft that we did. But again, I would caution that, you know, we're not re-arguing the case at this point, nor are we accepting new evidence. But with that, I would offer you a few minutes if you would like to provide any comment.
Yeah, I was wondering, was the person at the DEP made aware of the previous site visit and the determination from the DEP back in 2020? Can you hear me?
Yes, yeah, I'm trying to think how to respond to that.
Well, I would think it would be a yes or no.
I did not have a direct converstion.
Okay, so they weren't made aware of that.
With Mr. Clark. However, those
Okay.
people that would make such a determination work with him. And so I assume that he would be aware that there had been some work done out there previously.
So we're assuming they were made aware of that. Okay. The other point is when we were at the appeals board, they had voiced concern over moving farther back into the hill and the greatest practical extent to that. And that could be a hazard. And how was that addressed by the planning board in your documents?
There was some additional language, some additional explanation concerning the greatest practical extent standard. Let's see, we added factual finding number 7, which addresses the greatest practical extent standard. and provided a little more information about the deliberation that we had done.
I think another issue here is that the issue of the location being further up the slope is very different when you talk about a 2,100 square foot house compared to a 4,600 square foot house. And so at a 2,100 square foot house, it's less of an issue than the house that you propose.
The intent is to have the access to the garage underneath as on the most even land as possible, and not having an access to that at a 14-degree slope. And that was the contention, and a potential hazard to that, and also pushing farther up the hill means loss of more vegetation. I thought that's what the appeals board was addressing, and I don't really see how that was discussed, but.
We're looking at a 2,100 square foot house, the existing footprint of the
That's
existing.
not what we put a permit in for, Jack.
I know, and that's been the difference between us this whole time. We're bound to look at a 2,100 square foot house under state rules and under our rules. You proposed a 4,600 square foot house.
Well, those are rules, Jack, that for this is the first time in the planning board's existence that they have gone and told a applicant what size home they should have. And that was not done in the Smart property, and that was not done at the Les Priest property. That were approved in 2 meetings. So I would request that the planning board members go back and revisit those 2 applications.
Okay. Thank you. Anything further from planning board members? And if not, I would ask for a motion concerning forwarding of the revised notice of decision to the Board of Appeals for their consideration.
I'll make a motion to approve the revised hearing decision and forward it along with the attachments to the Board of Appeals.
There's someone that's looking to talk with a hand raised if.
Schultz.
Chip, can you see that?
Okay, I see it. I see it now.
Session where there's no.
If you could wait for just a moment, and I will get right back to you. We're in the middle of a vote, and I want to complete that, and then I'll come right back to you for comment. So we have a motion on the floor. Is there a second?
Second,
A motion and a second. Further discussion? Not, I'll call for a vote. Jack,
Yes,
Henry,
Yes,
Don,
Yes,
Bill,
yes.
and Paula, yes.
Jan,
Don't forget about me.
Jan, I'm sorry. I'm sorry.
okay,
I'm
yes.
gonna forget somebody.
No worries.
Okay, thank you. Okay, Mr. Gottschalk. You're muted. I'm sorry. We can't
Yeah,
hear you.
I'm taking it off. The vote has been taken. I was just going to try to respond, Ms. Clark, to your question about factual errors. And I had a chance to read the draft opinion, which you just approved, and I think there was a very substantial factual error in it. And I just wanted to mention that. And that is that it has been said that the argument that the Marash has made for the placement of the house was one of convenience. That's an absolute falsehood. The argument was one of safety. And to Mr. Comart's point, I don't think there's been any examination of how the 21 square foot or footprint would fit on the plot relative to the slope in terms of whether it would reduce significantly the safety risk that is obviously present with a 14% slope. And the other important error that I think the board should be aware of, because it'll certainly be pressed if the Marashas decide to appeal, is that the main guidelines, while you have said they apply, were never cited, were never talked about during the hearings below before you made your first decision. They were raised only on appeal to the Board of Appeals. So the Marashas have never had a chance to consult with a lawyer, talk about whether the main guidelines in fact have no exception. The statute does talk about the greatest practical extent. It does talk about overlaying the 20, in this case, the 21 foot footprint to determine whether or not some of it has to extend within the 100-foot line. No chance, no opportunity to be heard on this by the Marashas. It was adopted by the planning board only in this revised decision. It was raised to the appeals board as a matter of context. So I think as a matter of fundamental fairness for a board to say you're now relying on a state statute that was never invoked during the time of the actual hearings without giving the Marashas a chance to be heard on it is frankly a denial of due process. And if I were a planning board member, I'd ask, why are we not giving them a chance to be heard on this? Thank you for hearing me.
Thank you for your comments. You know, I don't want to get deep into discussion about all of these points, but a couple of things just quickly. The notion of convenience, the reason that was raised was that was a question that came from the Board of Appeals hearing. The Board of Appeals was questioning whether or not the greatest practical extent standard should address the convenience of the applicant. And so in the document, it was raised in that context only. That was not a consideration that was raised by the planning board. It was in response to the Board of Appeals. On the shoreline zoning guidelines, I would just say very briefly that they are the underpinning of the land use ordinance. Reed Field's land use ordinance, when it addresses ordinance provisions dealing with activities in the shoreline zone, the municipalities are required to provide those to the Department of Environmental Protection for review and approval. Which we did. The town has had its ordinance approved by the DEP and looking at the guidelines. So the guidelines are not something that we would, typically cite on their own. The ordinance has been reviewed and approved in view of the shoreline zoning guidelines. And they were only raised in this context for clarity. There was a lot of confusion about interpretation of the standards. And so those shoreline zoning guidelines were not being invoked as a new standard to apply, but to clarify and provide additional information about the basis for the planning board's decision. So. Carol Dorambos.
Hi, Paula. I just had a couple questions. So the thing you guys just said about the new ordinance. So if what he's asking with a bigger plan, and the whole thing is he's changing the use of this existing structure. This has been like a weekend trip home, and he's hoping to retire here and right off into a nice ripe old age, which you have to have concerns about ice and safety as you age, which is why he's really having a hard time setting it back to where it may be deemed by a statute, but may not be practical. And and you have a structure that's 14 feet from the lake going back to 75 feet from the lake. And I thought that was the goal of rebuilds is, and
Who is this? I don't know.
my name's Carol Dorenbos. I am a resident, long-term resident, and I'm also on the select board. And I've witnessed several meetings for this site. My question is the new ordinance that you refer to able to grant him exactly what he's asking if he reapplies using the new ordinance? Because this is a completely different use of this location with a garage. You know, a year-round resident is going to want that, especially in an old age, and an office to continue a sort of work and to have grandkids come. I mean, it's a structure that he hopes to serve him for a very long time.
I don't think we are in a position to be able to say that the new ordinance would give him exactly what he wants. We've never really had an opportunity to review it at that level of detail, but the new ordinance does provide some flexibilities that the old one did not, in terms of achieving setbacks and getting credit for certain aspects of setbacks that are achieved.
It can't be mentioned if it isn't in the minutes.
Jack, I don't know if you had something additionally you wanted to add on that. But we've not had this proposal come before us under the new ordinance, but did recognize it as, as a possibility because of those new flexibilities.
Henry has his hand up.
Henry?
My non-virtual hand, sorry. I just wanted to reiterate, Carol, I appreciate your comment. Tom, I appreciate your comments too. And as a board member here, I just wanted to acknowledge that. And I appreciate members of the public here today trying to ask good questions. Mr. Meyer, your phone is, your line is not
Yes,
muted.
I'm sorry. I'm trying to turn it off. I was trying to raise my hand. I apologize.
That's all right. I'm with you there on the technology. It's somewhat intimidating. But I guess I wanted to say, it's land use. Look, land use ordinance is very complicated, and it's very hard for people to take the emotion out of it. So it's important to remember that these rules are not written for particular situations. They're written for a great number of situations and with the least exceptions. And I think that's we don't manage by loophole. That's not the purpose of the ordinance. The purpose of ordinance is to be fair to all members of the community and society. And while today you may be thinking that this is unfair, or there's some components of this that are unfair or appear to be unfair, I also really ask for your patience in respecting the fact that the ordinance and the statutes of the state of Maine are not easy to understand, and they do take. I mean, I've been on this board quite a long time, and I know Paula has been on it for an awfully long time with Jack here too, and it takes years and years of expertise to do this. There's people that do this for their whole career, and maybe even some of you do this for your career as well. But I think it's. I'm not saying that it's all correct, but I'm saying the procedures and the emotion of it are hard to reconcile sometimes. So I would ask for your patience and faith in the process. And I am confident that the Morashes will build a nice home here in Reedfield and succeed through this painful process. And I would just I just wanted to put that on the table because I really feel it's important. I don't think this should be a contentious situation moving forward. And I think we have an opportunity here to do the right thing, and we just have to follow the process. That's unfortunate, but that's the way it is.
I'm just saying, Mr. Morris has provided information raised in a previous meeting. I know there was some notation of exceptions had been made in the past, and Jack said, I don't recall any. So Mr. Morris is trying to answer that, and he's submitted sorry, that information several times, but it's not allowed to be reviewed. And I think you guys said there's no new information, but then you had a new piece of information from the DEP that contradicts something for previous. So it's I gotta be frustrating from the Morashes that they've got more information to feed in and they're blocked from doing that for consideration. That sheds some light on, he's got a very small property. There's not a lot of wiggle room on what he can or cannot do. And it seems when you cut into a slope, gravity's gonna eventually win. I went around the lake and saw one that was pushed back into an incline and the retaining wall is caving in. I think eventually nature wins and it's gonna get its way. And I think they're just looking at, safety and a very long time spent at that property, using it the way they hope they can use it for family gatherings for a very long time. And I know maybe reapplying with the new statute, I don't know. I hope there's something he can do to make this property useful. Otherwise, you leave him no choice but to rebuild 14 feet from the lake. And I don't think that's what anybody wants to have happen.
Thank you, Carol.
Keith Meyer wants to speak, but he's on mute.
Mr. Meyer, you're muted. Sorry, we still can't hear you.
Can you hear me now?
Yes, yes.
I apologize. I've got a problem here. I'm 80 years old. I'm reasonably good with this stuff, but all of a sudden I've had a problem. I apologize. I have 2 points I'd like to make. One is that I would want to make sure that the record reflects the comments of Mr. Marash and Mr. Gottschalk. And secondly, I received this afternoon a comment or a email that included a memorandum that was sent to the board. I am curious whether you received that.
We did.
Did you have the opportunity to read it?
We did.
Well, I hope that you've thought about it. We have lived in the Maranacook Lake since 2005, and we're concerned about the environment there and whatever. We just spent the winter there. The Marashes are people that are interested in all this, and all I want to say is that their lot, and with that 14% grade, is a unique piece of property. And to some extent, I'm taken back by the history of this, where the initial question was about roads and driveways, and Mayo Road was held to be a road, and we don't see much traffic there. That's kind of a crazy thing in one sense, but where the Marashes are, it's a difficult kind of property to get to. And what Scott is trying to do, in my judgment, is to facilitate living on that piece of property. And he is trying to obtain a piece of property that will take care of him in his old age. And I respect that, let me tell you. I grew up in these winters. Anyway, my thought is, I think that what has been done is not appropriate as far as what the Board of Appeals or we sat through that. They were concerned about the 14% grade and about the trees and about what would happen if he has to move that property back more than what it is now. And I don't see that being responded to. Anyway, thank you for your time, and I apologize for my inconvenience with the technology.
Oh, that's okay. Thank you very much for your comment.
Paula, this is Tom Maloki, a resident of Reedfield.
Hi, Tom.
Hi, and I would just like to comment, if I could, very quickly on the tone of this meeting, the tone of the Morash's response, and the tone that you are putting forth, Paula. It is very different than all of the processes the Morashes have faced. I think there is a beginning, a chance as Henry had mentioned and other people had, of this plan to come to fruition. But there is no more adversarial relationship that seemed to have been present, from my opinion, in previous meetings. I perceive that the people are looking at ways of making this work. The tone, from my perspective, has been very different, and I hope things can go forward and that they may be able to get their dream and still adhere to the provisions that necessarily have to be followed with the planning board. The tone of this meeting is different, and I applaud that.
Thank you for your comment, Tom. Okay. Planning board members, others, anything further? If not, thank you all very much for your comment, your questions, the conversation. We will be forwarding the revised notice of decision to the Board of Appeals. And as I said earlier, the process at this point is that there is still a pending action before the appeals board. And they will be determining how they want to move forward with that, how they want to schedule it, and what that process will look like. So again, thank you all for participating in that. And we do have another application on our agenda that we need to move into shortly.
Well, I did what I
We have Ms. Davis with us. She's online.
Okay. So the second application, second matter on the agenda for tonight is the re-subdivision of the Quiet Harbor subdivision. Chip had provided a memo about the circumstances of that application. And we do have Ms. Davis, who is one of the applicants. And I think what I would ask at this point, if you could just provide a summary for the planning board of the application, the situation, and what your request is, that would be helpful to us.
I will do my best. 3 years ago, Dave Dolly and I purchased a lakefront lot that was between our two properties. Thought it was a great idea, divide it. Half of it would be incorporated into my property, half into his. Neither one of us wanted to see development. We just wanted to keep it as a buffer. So we did that. And I did actually talk to the town back then, but Chip Stevens wasn't there then. It was somebody named Jamie. And I just found this in my notes today. And he had told us to have the deed description and the survey go to the attorney, and then the attorney would take care of it. So that's all we knew at that point. So we did that, had it surveyed and split. And I've been trying to find out since about the tax bill. And I guess my repeated questions kind of brought all this to light, that it wasn't done properly. And we didn't know that. That was never the intent. And I do apologize for all this. And that's where we are today, is how do we make it right?
Okay.
I hope that was clear.
Yes, that was helpful. Thank you. Chip, do you want to run through and summarize the mechanics of it, the lots?
Sure, I won't read the whole thing, but I'll give you the background. As you know, Dave Ledoux, the assessor, is in the same office as I am on Fridays, and he was having difficulty working with Ms. Davis and Mr. Dolly about the taxes and what was going on and how they should have been done and everything. And he asked me for some help in understanding what happened with that property. And so I went into deep mode of due diligence, looking back, and I think Diane, described it right, except that the two pieces that weren't accomplished in the process is, number one, Quiet Harbor is a subdivision, and in such, they have to come to the board to ask for any rearrangement, expansion, contraction, or remapping of property lines. That was never done. And I'll also make the caveat that they did have legal representation that, in my opinion, didn't represent them very well. So give them their due there. The other part that they didn't do is they did not incorporate the two pieces, the two halves, into their properties. They had simply divided it to this point, to this date. And to this date, there were two half lots there. As we all know, the most important part of planning and zoning is conformity. And you're not supposed to make a lot less conforming. You can't make it less conforming. And that's just what this did. As you know, subdivision lots are smaller than is required in our ordinance and our rules and everything, but that's what subdivisions do, so you can have a properly planned community. And there's some pretty strict rules. And when they divided this, they didn't come to the planning board, and they left two half properties there that the assessor was trying to figure out how to deal with tax-wise and everything. And that's when I ran into this and tried to figure out what was going on. Both Ms. Dolly and both Mr. Dolly and Ms. Davis have been very cooperative. Mr. Dolly would be with us here tonight if he didn't have to be at a business appointment way up in nowhere, Maine, that has no reception. But he is very understanding of what's going on here. I believe they both understand what's going on here and have worked with me in setting up how we could rectify this situation. I would do it myself, but this does involve a decision by the board, albeit maybe abbreviated with your new rule that was incorporated in the last LUO. So long and short, up until this time right now, there are two half lots between the two applicants, and they haven't been brought into their own lots. Both are willing to do that. But in order to do that, on the Kennebec Land Trust, they had submitted a new deed, a new drawing, and I think that needs to be withdrawn and turned around to get your decision done properly. They've agreed that. Then they have to come to you, which they're doing tonight with Diane as the representative of the two, to request the division and then immediate incorporation to each of their properties. That would make this legal. This would make two properties, two lots that are more conforming, everything that we like to see. And it's a fix that would take this out of the whole realm of a long, drawn out kind of arbitration, legal type thing. And I think that's about where we are right now.
And this is what we had hoped for 3 years ago when we bought the property. We just, I guess, didn't do it right, but that was the original goal.
I had a
So
question.
back to the mechanics for a minute. We've got lots 20, 28, 29, and 30. 29 is split in half at this point. And so the fix is to take those two pieces and merge them with lots 28 and 30 on either side to make two larger lots out of what was 3 initially.
I think you also have to make a determination, since it wasn't done originally, that just doing the split, it is advantageous, it is right, but it's in your purview to grant that split with the incorporation. That wasn't done before.
Yeah, and so that, I mean, that's the circumstance as it exists currently, that we've got those pieces that need to be incorporated into the other two lots, into 28 and 30. So given the new language that was adopted last year in the wake of the is their name Quentin, the Sturdivant Hill Road lot line issue that we dealt with. We had agreed on some new language concerning revisions to approved plans. And one of the circumstances under which we can take action on an application and not require that it be treated as a new application, not go through that process, where we could look at it in a single meeting, basically, is a situation in which the reallocation of lot lines among 3 or fewer lots, when the planning board determines that such reallocation will not result in the creation of additional lots or adverse impacts on the subject or adjacent properties. So if that circumstance exists, we can address this outside of the context of the new application process. And it seems to me that that is the situation that we have here. We will not be creating additional lots. I've not heard any discussion about any adverse impact. I think it will only be a positive impact if the lots are made larger. So,
Paul,
yeah, Chuck.
I assume that there would need to be a new survey of both of these newly created lots, and then a new subdivision plan that showed lots 28 and 30 and drops off 29 and has new dimensions, boundaries for 28 and 30. Right?
Yeah, I assume, Chip, that when you mentioned the Kennebec Land Trust, you were talking about the registry.
Registry of Deeds, which this would have to be registered with them and then with us, yes.
And so it would require a revised subdivision plan
That we would sign off on.
that we would sign off on. Right.
So a survey and a new subdivision plan. We signed off on and then recorded with the registry.
Right. So is that the process that you've been discussing, Chip? Or?
That is a simplified process, which I salute. I was going through the process of unwinding and then doing the full split and merge again legally, but if the board can do that simply and make it easier for Ms. Davis, who has been very cooperative, I would salute that.
Well, they split lot 29 and they each have a deed for part of lot 29, I assume. So there's
Right.
gonna have to be a new.
Yes. Which created tax problems that uncovered this whole mess.
Yeah. I don't know exactly how somebody would do this because you now own 29A and somebody owns 29B. But you're gonna take 29A and merge it into one piece of property and 29B and merge it into the other piece of property. So I think a real estate attorney would do that and would work with a surveyor to get the exact dimensions and then do a new subdivision plan, an amended subdivision plan that we would sign off on. And then you would record the new deeds and the new plan.
You know, I think the unwinding that you're talking about, Chip, would take place with with a real estate attorney and, with the deeds and so forth. I don't think there's anything for the planning board to unwind because we never approved any modification to that subdivision previously. So what we would be looking at and the action we would be taking would be to approve what's in front of us right now, which is to take half of lot 29 and merge it with 28 and take the other half and merge it with 30. And that's what the new subdivision plan would look like, the one that would be filed at the registry. So there may be some complications with the deeds and so forth, but that is not something that the planning board would weigh in on. That would have to be cleaned up, outside of this process.
The board would possibly think of doing what I have to do every now and then, not real happily, is I'd like it referred to as an after the fact approval for the split and incorporation.
Well, I don't think we're approving the split. I don't think there's any reason for us. I don't know what others think. Please weigh in, but I don't know why we would step back and approve that split that happened in the past. What we're approving, I think, is the merger of half of 29 with the lots on either side of it. I guess I don't really see the reason for the unwind that you're suggesting. I don't know if others think differently, but I don't see a need for it.
Are you suggesting that that's step because it already occurred?
Right.
Yeah, it's not material to the subdivision plan. It's not material to
Correct.
the result. So therefore, yeah,
Right.
I agree. So I agree. I just
And
tried
it's
to
not
work it out.
something we would have proved anyway if it had come
Yeah,
before us.
It's not
That's
our
another
business.
reason not to do
It's yeah, it's not our prerogative. Yeah, that makes sense. Yeah, so I would agree.
Goodbye me, I give up, stop.
It's not an after the fact approval, it's it's a
No.
revision of the subdivision.
Right,
Right.
it's the subdivision, the new subdivision structure is what needs to be approved.
Right.
Makes sense.
Other discussion about that? Okay. So if there is, conceptual agreement on approving that, we're able to do it in this single meeting under that new provision. If the planning board feels that those circumstances are the ones that we're operating within. And that is in the site, in Article 6, the site review, it's section H, revisions to approved plans, and it's the first paragraph that outlines that. We could go ahead and approve it, subject to those actions that Jack was outlining, revising the subdivision plan, recording it and so forth, and bringing it back for the planning board's sign off, as is our usual practice. Was there anything else, Jack? Was that a revision of the subdivision plan, recording in the registry, and the planning board?
We have to
Sign
sign
off.
it. Yeah, we have to sign it before it's registered.
Yeah. Any concerns? Any questions? If not, then we're ready for a motion.
Yes, I can make a motion to approve a re-subdivision that would allow part of lot 29 to be merged into lot 28 and the other part of lot 29 to be merged into lot 30. And we need to be surveyed, and we need to see a new revised subdivision plan for our signature, and then filing in the registry of deeds.
There's a second.
Second.
Motion and a second. Further discussion?
Just for clarity's sake, the sign off is not something that we have to reconvene for, but we all just have to get to the town office and sign it.
Right,
Right.
right. Yeah, we've done that before. Yeah, at your convenience, you can stop by and just sign in the signature block.
That sounds fine to me.
Okay. All right. Take a vote. Jan,
Yes.
Bill,
Yes.
Henry,
Yes.
Don,
Yes.
Jack,
Yes.
and Paula, yes. Okay. Thank you very much, Ms. Davis. And you can work with Chip on the particulars. He can talk you through that process, and hopefully you'll get this cleaned up in short order.
That
So-
would be great. Thank you very much. I appreciate your time.
Thank you. Good night.
Good night.
I had one more item that's not specifically on the agenda that I wanted to put out for just a brief discussion. And I guess for some affirmation, that's what I'm looking for, affirmation. Last week, the select board hold an annual committee and board chairs meeting. And it's an opportunity for the select board to get together with board and committee chairs and just hear a little bit about what's going on. So each board gets 5 minutes, what have you been doing? And so obviously it's not a very in-depth discussion because there are quite a number of boards and committees. So everyone did a little 5-minute piece on what the activities have been. And what I wanted to mention to you was that in the course of that, there was a question asked of me about, it was a very direct question about whether or not the planning board had met in person in recent history. And my response was not as a complete board. There have been, a couple of members that have on occasion attended in-person meetings, but that principally we are meeting remotely and participating virtually. I was asked why that was so. And I had a couple of responses to that. It was clear that I was not going to speak for each individual on the planning board. I don't think that's appropriate. I wasn't comfortable doing it. And I know that Dennis Price wasn't comfortable going down that road either. And so I said, I'll respond from my own perspective. I'll tell you why I prefer to participate remotely. And I did that. And, in part it is COVID based. I mean, I have a general discomfort being in crowds and in-person meetings, and I tend to minimize them if possible. It's all about risk minimization for me. And but there are lots of other reasons why people participate remotely. I mean, and there really wasn't much opportunity to get into that and to talk about it very much. We had 5 minutes and everybody was anxious to move on because they had a regular select board meeting to conduct after this boards and commissions piece. And so I was left pretty unsettled by the whole thing. And I wasn't quite sure what I was going to do about it. But, it took me by surprise. I did not expect that. And I didn't feel really prepared, nor did I have enough time to talk about it as completely as one would like to when a question like that's posed. Interestingly, Dennis emailed and we wound up talking on the phone the following morning. And, I do want to tell you that he is very, very supportive of the work of the planning board. And he made that very clear. And he suggested that if I wanted it, he would provide an opportunity to address the select board if I thought a fuller explanation of this would be useful, helpful, productive. And, I've been thinking about that, and it may be, but I told him that I was not comfortable doing it until the planning board talked about this issue a little bit because I don't want to speak for the entire planning board unless I can do it accurately. And I want to be comfortable that, you know, what I'm thinking about this issue is the same thing that all of you are thinking. And if it isn't, then we can talk about that. But I just don't want to say something that isn't representative of the views of each member of this board in front of the select board. So I just wanted to put that out there, spend a few minutes talking about it. I told Dennis that, you know, in my mind, there are, of course, you know, the whole remote thing, obviously, everybody knows it started, it was an outgrowth of the COVID situation. However, and that, you know, that persists. Some people still have a general discomfort, like myself, being in crowds. I'm not the least bit interested in contracting COVID. I haven't yet. I'm not interested in doing it. And I think there's lots of opportunity out there in crowds. And, you know, the question at that point was, well, you know, don't you go shopping? Don't you do anything? And my response is, of course I do. You know, I'm you know, I'm not this crazy eccentric holed up in her house for the rest of her life. Yes, I go shopping. I do things. I go places, but I minimize risk. I wear a mask frequently. I choose to do that. I pay attention to where I go and, you know, what the situation is. But everybody manages all of that in a different way. And I told Dennis that there are lots of reasons why at this point participating remotely makes sense to people. And there are different reasons. You know, it's not just because of COVID. In some cases, there are health issues that are concerns. There are childcare issues potentially, or other types of care that need to be given. There are schedules, and you know, I know in my own case there are cases where if I had to go to a meeting in person versus being able to do it virtually, either I might not be able to do it because of timing and schedules, or participating virtually just makes it so much easier and less stressful because of the timing issues. And there are issues of travel. I mean, if people are traveling, sometimes there is an opportunity to participate remotely. So there's this wide array of reasons why people choose to do that. And that is the piece that, you know, I outlined a little more fully from my own perspective with Dennis. But I thought that it might be useful to discuss with the select board more broadly. But I really wanted to get your input first and not do anything until I heard from all of you that we're on the same page. So that's my spiel.
It's a good spiel. I appreciate your thoughts. I'm happy to share a few quick thoughts if you want.
Sure, please.
You know, I think I guess I would question, like, why are they even asking that question? I don't really understand the purpose of why someone would even ask that question. So I guess I would slightly critically ask that question back to them. I mean, I know we're not going to, but I think that's it causes me a bit of pause. Okay, so the second point I'd like to make is I think the world has changed permanently. I don't think we're in a situation where I think the hybrid model of working, a hybrid model of meeting, a hybrid model of traveling, et cetera, is here to stay. I think Americans and people have become used to that, and for a number of reasons that you already outlined. So I don't think there's any question that our general society is that way, including our employers and places like that. So again, I would ask what's, I don't, the third point I would make is I don't think the quality of the meetings are any less, or the effectiveness of the board's execution of its role is any less because of the virtual format. I
I
would
was able, oh, I'm sorry, go ahead.
interrupt, please.
No, I was just going to say, I was able to make that point in partial response because there was a point in that discussion where something about, well, I've seen a planning board meeting and, and how can you expect to review architectural plans remotely and there's all this shuffling of paper and how can you see them? And I said, oh, wait a minute, all of those
Oh.
materials are made available not only to each planning board member in advance, but they're also available through the town website to anyone who wants to see them.
They're actually more accessible, Paula.
They're
I
absolutely.
would say
Yeah.
more accessible than they have
Yeah.
ever been.
Yeah,
And the details are much more accessible too, when you can have them on a screen and you're zooming into certain parts. I mean,
yeah.
it's, for lack
Yeah.
of being.
So I did make that
ridiculous
response,
premise.
that particular comment.
I have just two more quick points. One is I do think there's value in having a physical meeting or board members present for certain important cases that require perhaps a more physical presence. And I think we've seen that and we've done that. And I point to the Safe Space Meeting House application that we had where we actually did come together physically during the height of COVID in order to
We did a
in order to
hearing
do that. Yep.
during the high COVID.
So I think it is I think one point is that we are coming together. We do it at our discretion, but it's an appropriate discretion, and I think there's nothing wrong with that. And then lastly, and then I will definitely be quiet because I know others want to say something, but not that you're interested in my personal medical history, but the reason I was not at the last two planning board meetings was because I was in hospital with COVID. So
Henry, oh no.
I'm sorry, Henry.
I have been recovering from COVID and I still have some symptoms, but COVID is still here despite what people say. And I think it is completely appropriate to be in a remote situation in as much as possible still. And so I'm personally fine, but I'm still very tired and have a lingering cough, and it's been almost a month. So I would not be comfortable personally being I don't even go to my office most of the time now. So I think it's important to be sensitive to people's conditions and also sensitive to the fact that COVID is still very much here and very dangerous.
Thanks for that, Henry.
Yeah, I'll jump in and echo, Henry, what you said. I also had COVID in September. So yes, I can also attest that it's out there. And of course, I was away, I was traveling, and we went out to Colorado with our camper, and I thought, hey, this is perfect. We can isolate and we can travel and do things, see things. But there were a couple places where, we did see people or we were in enclosed settings, not totally of our own decisions, but mostly, I mean, if you go to a national park and you want to see the movie before to get the setting, and you think, it's okay. Well, maybe not. So yeah. Anyway, sounds like I fared a little better than you did, Henry. That it was.
It impacts people differently.
Yeah, it was, for me, it was mostly about 3 days and I was pretty much back again. But I also have a 93-year-old mother that I've been tending out every week on. And so I think about her. And so, yeah, I'm certainly much more comfortable with this arrangement. And I think the other big thing is, we are all volunteers, and I think it's in the town's interest and in the community's interest to make this whole thing work, and I think we are making it work. But I think it's always been a challenge to get us all so that we can, and I think this arrangement does allow that to happen. And I think if they want to start insisting that we go back to another arrangement or in person only, I think, there may be some people that will decide they've
Yeah.
put in enough time. So I think that's important to point out.
And I would
Absolutely.
also point out that that's not a policy they can make for one board over another. That would have to be a policy that would be a town-wide policy. And if they did do that, then they would potentially have negative impacts to their entire volunteer base on all
And,
committees.
they did put out a policy because it basically, it's kind of ambiguous. It's not a crystal clear policy. I've read it a couple of times and I'm thinking, well, I don't know about this, but they've made it clear that, it's the wish of the select board to encourage that boards meet in purpose, but in person. But Dennis made it very clear to me that, he's not the least bit interested in being the COVID police, the meeting police, and, making any decisions for people about how they're going to participate. And I think he's perfectly comfortable and happy simply leaving the decision to each individual, based on their own reasons for why they're making the choices that they're making. And I believe that to be true of most of the select board members. I think that is their position as well.
I wanted to say, I too have medical reasons for not wanting to be at in-person meetings if I can avoid them. So I too want to minimize risk, but also I do find it easier to have access to all the documents on the computer rather than making copies of everything and coming to a meeting and hope that I have all the copies of everything, the latest. And it's just, and it's a lot less paper. And as Jan said, you can zoom in on things on the computer and see things. I do think that, we have to be cognizant of people in the audience in person and on the screen to make sure that they feel included and noticed. So everyone can participate equally. But I think we've been doing a great job.
In terms of the premise of the question, was there a concern about quality expressed at all? I'm really struggling to understand where it's coming from. I feel like we have really high attendance. I feel like we do good work. I just don't get it.
There's a lot more that could be said about it, but I'm just not comfortable digging into the detail.
Okay.
So is it just a displeasure with certain members of the planning board, or is it a political perspective they're having? Or, I mean, is that really what we're talking about here? Or is there actually like if there was a quality concern, or they were really worried about a fundamental issue,
Sure.
then I would like to listen to that concern from the select board. But if not, then I think it's,
like I said, my impression is that the majority of the select board members are very supportive of the work that the planning board does and the way in which we do it.
The only other thing that I'd like to add I concur with everything that's been said, but I am probably the poster child as somebody who likely would not be able to participate in the way, to the extent, frankly, that I'm able to now. I'm a working mom with 2 small kids whose husband travels for work regularly. So I'm here in part because I have the flexibility to do this. Another factor for me, I mean, it's the same for everyone, but, I have a child who's recently been diagnosed with asthma. So COVID has a whole new dimension for us at this point. And, we're being careful in a way that we probably had stopped being for a little while. So there's too, but I concur with Henry, if there is a legitimate quality concern or a participation concern, which I can't imagine because most of us are here all the time, but the substance of that, I'd certainly be interested in. And otherwise, I don't have much interest in the question.
Okay, thank you, Jan.
And I'll add that I travel a lot with my job, and the fact that I can participate remotely allows me to continue to volunteer my time for Reed Field in a capacity in which I feel like I have some energy and skill set towards. And if I was to be asked to participate only in a physical sense, I too probably would not be able to continue my service in this capacity, because I'm just not able with my schedule to be there. I would of course be there sometimes, but it's just not going to be as active. And I feel like the board, when we come together for these meetings, I feel like we have very active participation, we have active discussion, we have our videos on the entire time, which is extremely important. So it's not that we're doing something else at the same time. We are present in the moment. And I think that's an important, perhaps misunderstood perception that could be out there too. So I think that's
Is it also the case that when we're doing Zoom that they're actually being recorded by the town and can be used later?
yeah, I believe this one is being recorded. I believe that's the case. Yep.
Okay.
Is that not the case for in-person meetings?
I don't think so. I don't think we ever recorded them in the past.
Yeah, I don't believe that. I mean, it's been a while since we did in-person meetings with any regularity, but I don't think that it was the practice to always record those. Some of them may have been certain hearings perhaps, but I don't think each meeting as a matter of practice was recorded. But now that, with it's easier, to do
Sure.
it. If it's a remote meeting, so it's more likely to happen.
Well,
Bill, did you have anything you wanted to add? You're
the sole in-person member.
our token in-person member.
I enjoy coming to the meetings because when I'm traveling, which I do a good percentage of the time, as you know, I am watching you guys do whatever on an iPad from wherever I am. So this is sort of a get out and have some fun in fresh air. So nice.
Wow, your idea of fun and mine are just really different, Bill. I mean that in jest, of course.
Understood.
Well, thank you all for that. So I assume you don't have any objection to my having that conversation with the select board and spinning this out in a little more detail for them so they understand.
You can tell them they can watch the recording of our conversation.
Yeah.
They can you can just edit this piece and give it to them to watch.
Well, yeah, I could.
Or not, but we trust you to convey the message as it needs to be conveyed, apparently.
I did go to that meeting last week in person, and I did it in large part because this issue, it keeps coming up, and I found it amusing actually that in the front row facing the select board, there were a number of other people in the room, but there were 4 chairs in a row, and it was me, Bruce Hunter, Rob Peel, and Andy Tolman, all doing a 5-minute presentation for the select board. And when we first got there were very few people in the room, and so we all kind of went in with a mask in our hand, but we were trying to figure out when and if we were going to put it on, and more people started filtering in, and so each one of us, after doing our 5-minute presentation, sat down, immediately put a mask on. So it's like, 4 little monkeys in a row. Nobody else in the room had a mask on. So there's the 4 of us. And, but anyway, that was probably my token in-person meeting for the next 6 months.
I'd also make another observation that I've heard. I like you all, I live in this, very active in the community in various ways. I've one kid left in high school, and I'm around town. But one of the things, this happens every now and then. It sort of ebbs and flows, cyclic. I've been around long enough now where I can say it's cyclic. At least that's my opinion. Is that there's a thing people generally hear about something that the planning board has done, or even the select board has done, in my opinion. And there's sort of an animosity that builds, or a misperception that builds around some of those things, and it sort of has a life of its own. And I have noticed recently, and I think it's probably stemming from some of the more popularly attended activities that we've been reviewing maybe earlier this year. And I think there's sort of a bit of an animosity built towards maybe the planning board's strictness, I'll call it. But sort of like along my comments tonight, one of the things that I think is really important, and I try to share this with people when they bring something up to me when I'm at the dump or wherever. But I mean, I think it's important for people to truly understand that, these land use things, people do not necessarily understand land use regulation and ordinance. And I think it's really hard for people to separate the emotion from the sort of the rules of the road. And I think once people sort of take a breath and really sort of calm down and think about it, I think most of the time rational thought sort of wins. And so I think there are people that just wish there were none of these rules around. But I think that's a battle that this board every planning board fights against in every town in Maine. And I think we just need to, just keep things in perspective. And I think also the select board sometimes, whoever's on it, it comes and goes. This board tends to be less turnover rather. But I think it's important that they also challenge themselves to have an appreciation individually for the different committees and boards that they have in the community, and support their expertise. And I think that's sometimes forgotten. And I think I just sort of, sorry for my soapbox, but I think it is very important though to talk about it a little bit and acknowledge that it's an important thing. You don't want to upset the system too much, because if you do, the town will have lots of challenges and lots of issues. And I think the town of Reedfield is very lucky compared to other communities I've seen in the quality of its volunteers that it has on all boards.
Yeah, I think many other towns, maybe most other towns, or towns of this size, have a very different board makeup than we do.
Mhm.
So I agree with you completely. Okay. So the last thing, and we're just going to touch on this very briefly, Chip had he had sent out separately the legislation concerning accessory structures. And,
Yes.
I would say about that, we're going to need to spend much more time with that and to figure out how to address that appropriately in the ordinance. There's a deadline in there of July 1, I believe, next year, for towns to be compliant with the provisions in that statute. And so that means essentially that we have to have a package ready to include with our ordinance changes this upcoming winter, something that addresses the accessory structure situation. So I don't know if there's anything in particular, Chip, you wanted to mention. I don't want to get into the details of it tonight.
I'll be brief for you guys, I promise, I swear to God. Yeah, I was approached by Eric last week, or week before, with a deadline of early March for any changes, so they can get through them smoothly next year, the ordinance changes. This is a unique one. We now have a final, which I sent you, state, it won't be final, I'm sure they're gonna change it here or there, but we gotta deal with what we've got now. The state ordinance on auxiliary dwelling units. I took some time last week and went through it line by line, highlighting both for Wayne and then for us here in Reedfield, which pieces I think that we're gonna have to be looking at in our ordinance. And so what I ask of you is just to take that sheet sometime, put it where you read sometimes. And then as you go through that, go through the ordinances and see, highlight with a highlighter where we've got to change things to make ourselves jive between the two of us. Because there is going to be confrontation. Everybody's already told me, well, it's going to change here and there. We got to deal with what we have right now. So I'm already getting questions. I'm already pushed back quite a bit on July 23rd. But I'd really like to have some support on, where we're going and all, because it is important. And I think it's really going to change certain things we have in our ordinance. And that's about it. And I have one other thing when we're done with this.
I would say on the ordinance revisions, typically I have a list, like a running list that I keep of things that come up that we might want to modify in the ordinance. I have nothing on my list right now. We made quite a number of revisions that were just effective the last time around. But if there are things that come to mind for any of you, jot those down and we'll compare notes at an upcoming meeting and come up with a list. And if the only thing that we need to do this time around is the accessory structures, that's fine, but there may be some other pieces as well. So just keep that in mind and we can talk about it.
This thing we dealt with Morash, I think we should change the reconstruction thing to more closely follow the state.
Yeah.
It's much clearer.
Yeah, there was that, and then actually you and I had talked about the language in the relocation section versus the reconstruction section. And I think the relocation piece had some language that was clearer as well that could be carried over to reconstruction. So
I'd also be willing to take a look at the accessory dwelling unit changes and see where we have to change our ordinance. I'll take a look.
okay, great, thanks.
We do need a meeting next month. I already have one application from Tallwoods. It's very simple. It's a division in Tallwoods that's in Winthrop, but because the whole subdivision of Tallwoods touches on Reedfield, it's going to be even simpler than tonight's one. So that's the one thing we have at the next meeting.
So we'll have to talk about when to do the next, when to do a November meeting. The second Tuesday is election day. And
The 8th, right?
yeah, so we might want to, and then, well, I suppose potentially we could push it to the 15th, which would be the third Tuesday, because the week after that is Thanksgiving week.
Yeah, I can't make the 15th. I'm away, but I'm away. Like I can't, there's no way. I'm in a different time zone. I'll be asleep, very asleep.
Set your alarm, Henry.
But don't let that deter you. Please proceed.
You
I
just
can
have
do
the
the
one
15th.
application pending, Chip, is that right?
What's that now?
You just have this Tallwood thing pending? That's,
You could do it real quickly, very quickly in a quick Zoom meeting if you didn't want to have a full-blown meeting. It really has nothing to do with us. It's at the end of the tip of Tallwoods. The only reason that they're asking you is because in the Tallwoods subdivision, they require that both planning boards salute it and sign it. So I believe we could do it in 5 minutes.
well, I doubt that that will be true, but I'll probably
You're
be-
on.
Jan, what were you saying?
I was just saying I can do the 15th if needed.
How about you, Don? Would you be available the 15th if we did that?
Yeah, I can do the 15th.
And Jack?
Yep.
Okay.
And
Oh,
Bill,
it's my lucky day.
Bill,
I'm kidding.
Where's your dedication?
Bill, are
Henry?
you
At the 2
around on
a.m. planning board meeting?
Are you available on the 15th, Bill?
Yes.
Okay, well, why don't we say the 15th, Chip, for that?
Excellent.
But then the next one would be,
December.
you only have one in, yeah. December
Second
third-
Tuesday would be
13th.
13th?
Yeah.
No.
Yeah, December 13th. Which means there will not be one on, likely not one at the end of December.
Right.
Yeah. Yeah, I'd say we should probably start planning around that and just plan for one in November on the 15th and one in December on the 13th.
Whatever happened to the comprehensive plan discussion?
Oh,
There's a lot of laughing coming from that table tonight.
the comprehensive plan has been
Painful.
painful, suffering a number of maladies. A bunch of people resigned from the committee. It's been really excruciating watching KV-COG get up to speed. You know, the original KV-COG staff person that was working with the comp plan committee took a new job and very suddenly left. And so they got a new person, but that took an extended period and she was getting up to speed. And it's been one thing after another. And it's behind in every respect. The last two meetings have been canceled. So it will come at some point. I just don't know exactly when. So that's all I know. I mean, at this point, I'm guessing it's
Is the plan
likely.
still to try and have that done before the town meeting in June, or are they gonna?
Well,
just-
I think that I haven't heard Eric's current thinking, but I think he was at least considering a little while ago that we might need to modify the end date, you know, and change the schedule when it would actually go to town meeting and maybe think toward a November meeting next year instead of June. But I don't know if, you know, he hadn't decided that, but I think there had been some thought about it.
Well, the winter's a good time to chat about it as a board because it's usually not that much activity in the building realm.
Yeah. And I found, I don't know, I found the process very cumbersome and unfulfilling.
Mhm.
And so I was struggling with that.
Yep.
So I'll certainly keep you abreast of where that's going. And, you know, there's certainly, you know, there will be something for the planning board to consider at some point. It's just not there yet.
Okay.
So, that it? Anything else, anybody?
I would just, I just had a quick comment and then I think Chip, you had one more thing, right? You wanted to say? But you didn't. I had another comment just about the, I can't even remember the name of it now. What's it called? The solar project. What's it called? Sincartha. Is that right?
Sincartha. Yeah.
I had two questions. One is, Chip may know the answer. Chip, the project is obviously underway, which is great.
Yep.
But the part of my understanding, and maybe I'm misremembering this, but you guys would remember, was there was an opportunity for the citizens of Reedfield to buy into the community solar project. Was
No.
that part of?
No, it was not. People call about that. I looked into it. That wasn't done. And I tell people to call Sincarpa themselves and see if they can put something together. They can buy into solar in the overall solar part, if you know, in your electricity bill. But in terms of just a Reedfield buy into Sincarpa here, no.
I thought when they came before us, they said that be offered to Reedfield residents first.
I thought so too.
But
They absolutely did. In fact, we
Yeah.
can go back and look at the recording of it, I'm sure. I distinctly remember that.
yeah,
That's why I asked the question, because I've had several people ask me about it. I said, oh, because, you know, and I just said, oh, yes, I think there's an opportunity to,
Don't do that. Not in the approval, not in the NOD, and again,
Okay.
what I was told was that if, you know, some group in Reedfield wants to approach Sincarfa, go for it.
But if it was in the I mean, you know, it may not be specifically in the NOD, but the NOD doesn't include every single piece of the application that came before us. And, you know, they're bound by what they propose in their application, because that's what we approved. So I don't know if it shows up in there, but I'm, you know, my comment is simply that, you know, if it's not specifically in the NOD, that doesn't mean they're not bound to that.
That also came from the town manager too.
What was that, Chip?
Eric also relayed that same message, that it was not in the final agreement. So if somebody wants to look into it, I'm willing to enforce, but
no,
right now we
I-
don't.
yeah, well, this is a surprising answer, I guess, from my perspective, but I guess I would just say, I think there was a lot of people interested in that. And so I think it would, and I think that was the initial, that was definitely in the application process. I recall that for
I
sure.
mean, wasn't
Like,
that their whole pitch initially?
it was their whole, it was like
was
part of their whole
community
pitch
solar?
was
Yeah.
to sell it, to allow, and Reedfield would have, citizens in Reedfield would have their first shot at it, you know, before they open it up to the general communities. And I distinctly remember materials being provided along that line, and there was percentages discussed. And I mean, I'm sure we
Right.
could easily come up with a discussion train of all of this. So whether or not it was intentionally or unintentionally left out, I think the intent of the application was that for sure. Anyway, I think it's worth, sounds like it's worth us exploring our records a little bit and maybe looking at that. So that's what I would say. But that wasn't the point I was trying to make. I was just saying, if that is the case, how do we do it? And so I guess the question is, maybe we have to, you know, see if that's something they'd be willing to do based upon the applicant discussions that they had. And
Yeah, I mean, maybe the first communication is with Sincarfa, right? What is their intention with respect to that?
yeah, I mean, maybe they just say, yeah, that's,
I have a problem.
yeah, they may not be an issue at all. They may just say, oh yeah, absolutely, here's what we're gonna do. So
But Chip, didn't you indicate that they said no, they weren't doing that?
I can give Sincarfa a call. We're dealing with a Sincarfa that deals with an LLC, that deals with an LLC that's owned by a foreign entity. I'll try to dig where I can. I will ask the question and I will get back to you in December, October, whenever we meet again.
well, I think it's fair to remind them that they did
Well-
represent that to us.
yeah, I think it would be a little bit of bait and switch for our community if they didn't do it. And I think there's probably further discussion. So I would say I appreciate that the next time we meet, maybe you have an update, but I would say, just based on my experience with solar, time is of the essence in that, because if they're moving forward with their PPA and some
They're
other
gonna do
agreements,
something else.
they gotta be able to structure it in a way which allows that to occur. So if we wait too long, they you know, they may be in a corner, but you know, we may not work out for them, but it may be important for them.
I mean, it
This-
seems entirely likely or probable that there is something specific in the application materials about this, because we all remember it.
Yeah,
Yeah, which is why I brought it up, because some people have asked me about it and I just was, I
Yeah.
didn't know the answer. And so that's why I was asking.
And
That's
so,
certainly
I
not
mean,
accusatory. It's just.
if
just a
if it
question.
is, if it was part of their application, it's not necessarily optional for them. I mean, you know, we approved the application that they put forward. And I guess it would depend to some extent on, you know, what they put in there and, you know, how that was presented.
they passed the 1-year extension we granted.
Are we past it, did you say?
Or they passed it. I mean, they didn't get going for the first year. They asked for an extension. We granted them an extension, which I
I
think
assume they
expired.
weren't. There, I hope they're not past it, are they, Chip?
It doesn't, they've already started. They've done a substantial start, so they're on their way.
Well,
Yeah,
they
but did they
just-
make their
did they-
substantial start before the extension expired? That's the
When did-
standard.
When did the extension expire? Because they only started in October,
Yeah, it hasn't been very long.
a couple weeks. When did it expire?
We'll look into that. I'm not quite sure.
Oh, I just thought you'd know. Sorry. Yeah, no, that's okay. No problem. That wasn't my point either. I haven't even got to the question that I had. But the other point I had is, and it's more about an environmental thing. Is as you some of you on the call know the more than I do, there've been some pretty high profile violations for some solar projects recently related to the DEP and some not following the rules for wetland use and construction standards, things like this. And I just didn't, I'm just concerned, there was a lot of wetland associated with this project that they're dealing with, and they're around very sensitive areas. And I just wanted to, I just didn't know, Chip, if you'd been by there and just sort of checked it out, or if there's some way to just make sure that they're doing things correctly. I'm sure you're all over it, but as a planning board and trying to just it's a complicated project, is a large development compared to what we usually have in our community. So things like appropriate environmental protection measures are extremely important in this case, because there is a lot of ground movement that they're doing on a very large acreage scale. So I think it's important to make sure that that's being done right.
Got it.
And I think there was some recent challenges.
I've been down there 3 times. So yes, I've been down in the back of the field.
Yeah, I mean, they're making good progress, which is nice to see.
They've got a big bonus if they finish by December 31st. So
This year?
this year.
Oh, well, that's clearly an incentive for them. That's all I had. Sorry. Thank you for entertaining that. I'm glad I brought it up though, because I think it's important to find out the thing about the
Power share.
community buy-in power share. Yeah.
Okay,
Thank you.
thank you all. See
Thanks.
you on the
Thanks.
15th.
And
Right.
if my plans change, I'll be there.
Okay,
Good.
Okay.
all right.
Bye.
Good night, everybody.
Bye.
And